They left his house open to the sky for 11 days. Not open like a window left cracked in summer. Open like the roof had been partially stripped to the decking. The tarpaulin that was supposed to protect it had blown loose on day 3 and not been resecured. And 11 days of late September weather in eastern Tennessee had worked its way into insulation, into ceiling joists, into the plaster walls my grandfather had finished by hand in 1967 when he built that house for my grandmother on land his father had cleared before him. The contractor's name was Brecken Holloway. He ran a company called Summit Ridge Restoration out of a truck with a vinyl wrap, and a website that had 5-star reviews my grandfather later discovered were written by accounts created 6 weeks before his job started. Brecken had taken a $12,000 deposit, started the roof work on a Monday, pulled his crew off on Wednesday citing a materials delay, and not returned. My grandfather, Elias Prout, is 79 years old. He spent 41 years operating heavy equipment for the county road department. He retired with a CDL, a commercial equipment certification, and the particular patience of a man who has spent 4 decades moving earth for other people and knows exactly what machines are capable of when operated by someone who understands them. When Brecken Holloway's supply trailer sat in my grandfather's driveway for 11 days full of materials that Brecken had apparently paid for with my grandfather's deposit money, and then abandoned along with the job, my grandfather made a calculation. He called his former supervisor at the county road department. He borrowed a track hoe, and he moved Brecken Holloway's trailer to a location from which it could not easily be moved without my grandfather's cooperation. That location was 4 feet below grade in the back corner of my grandfather's property. But before I tell you what happened when Brecken Holloway came back for his trailer and found a flat piece of ground where he had left $12,000 worth of roofing supplies, and before I tell you what the HOA had to do with any of this, let me tell you what my grandfather found when he started reading the contract Brecken had given him to sign, because the contract was the thing that changed everything. And my grandfather had kept every copy. My name is Sierra Prout. I am 38 years old. I am a consumer protection attorney. And when my grandfather called me from his kitchen with rain coming through his exposed roof and Brecken Holloway's phone going to voicemail, I drove 4 hours to eastern Tennessee and read every document he had. Comment below where you are watching from. Because this story ends with a contractor's license permanently revoked, a fraudulent contract scheme that had victimized 22 homeowners in 3 counties, and a 79-year-old man with a track hoe who turned out to be the most effective debt recovery mechanism I have encountered in 14 years of consumer protection law. Part 1, 112. Elias Prout built his house in the summer of 1967 on 12 acres in Claiborne County, Tennessee that his father Clarence had bought in 1941 and cleared over the following decade by hand, and with a single mule named Porter, who Elias remembered with the specific clarity of childhood memories that attach themselves to animals. The house was modest by any standard except the standard that mattered to Elias, which was that he had built it himself, board by board and course by course, over one summer and into the fall, finishing the interior through the winter of 1967 to 1968, so that he and my grandmother Ruth could move in by the following spring. Ruth had died in 2018. The house was everything that remained of their 50 years together in it, and Elias maintained it with the attention of someone for whom maintenance was a form of conversation with the past. The roof had been original for 53 years when it began showing the signs that roofs show after half a century in Tennessee weather: granular loss on the shingles, soft spots in the decking near the north chimney, a slow leak over the back bedroom that appeared during heavy rain and had been getting progressively less slow over the previous 2 winters. Elias had gotten 3 estimates in the spring. The first 2 were from established roofing companies with addresses in the county seat. The third was from Brecken Holloway of Summit Ridge Restoration, who had knocked on Elias' door on a Saturday in March with a clipboard and the friendly efficiency of a man who had rehearsed his introduction enough times that it sounded spontaneous. He was 41, broad-shouldered, had the kind of confident physical presence that reads as competence before you have any evidence of it. He looked at the roof from the ground, asked Elias several questions about the leak, climbed up for a visual inspection, and came down with an estimate of $28,000 for a full replacement, new decking where needed, new flashing, ridge vent installation, and a 10-year workmanship warranty. The first two estimates had been $31,000 and $34,000 respectively. Elias called me before he signed. "Granddaughter," he said, "this fellow wants me to sign a contract. Would you look at it?" I drove up on a Friday evening, read the contract at his kitchen table with a cup of his coffee that was strong enough to strip varnish, and found 7 things wrong with it in the first read. The payment schedule required 50% deposit before work began. Tennessee contractor law recommends deposits not exceed 1/3 for residential work, and the Tennessee Home Improvement Act caps deposits at 50%, but flags it as a practice associated with contractor fraud in consumer guidance. The warranty language was circular, warranting workmanship against defects caused by workmanship, which meant any defect could be attributed to materials rather than workmanship and excluded. The contract contained a binding arbitration clause with the arbitration venue specified as a private company in which, when I searched the company name, I found a registered agent who shared a surname with Brecken Holloway. The materials specification was vague. Brand names were listed as or equivalent without any quality specification that would prevent substitution with inferior products. The timeline language said work to be completed in a reasonable time, which was legally meaningless. The licensing information showed Brecken's Tennessee contractor license number, which I looked up in the state database and found was current, but had a notation for a prior complaint from 2021 that had been resolved. The contract was signed only by Brecken's company, not countersigned, meaning it was not yet a binding agreement until Elias signed. I told Elias my concerns. He listened with the attention he gave everything, which was complete and without interruption. Then he said, "Is it the cheapest bid?" "Yes, by $3,000 to $6,000. Is it enough cheaper to take the risk?" "That depends on whether Brecken is legitimate or whether the contract structure tells us something about his intentions." Elias was quiet for a moment. He looked at the contract. "I know men who build things and men who pretend to build things," he said. "This man had the right hands." "What do you mean?" Elias held up his own hands, which were the hands of a man who had operated heavy equipment for 41 years. Rough, marked, functional. That young man's hands looked like that. He has worked. I took the contract home and made changes, reduced the deposit requirement to 30%, removed the private arbitration clause in favor of Tennessee courts, added a specific materials list with brand and grade specifications, added a completion timeline of 30 days from start date, added a penalty clause of $200 per day for delays beyond 30 days without documented cause, added a provision that all workers on the job must be covered by the contractor's insurance, which must remain current throughout the project, sent the redline version to Brecken. He called Elias the following week and said the changes were acceptable. He countersigned. Work began on a Monday in September. Brecken showed up with 3 men, good equipment, and the appearance of a crew that knew what they were doing. They stripped the old shingles on Monday, began removing damaged decking Tuesday, and had the roof in a partially stripped state by Wednesday morning when Brecken told Elias he needed to make a materials run. The tarp went up. Not well, but up. Brecken's crew left. They did not come back on Thursday. On Friday, Elias called Brecken's number. Voicemail. Saturday. Voicemail. The tarp came loose Sunday in wind, and Elias, who is 79 and was not going to climb onto a partially stripped roof regardless of the weather, could not resecure it. Rain came Sunday night and Monday. Light rain, but steady. The exposed decking absorbed it. By Tuesday, Elias could see water staining on his living room ceiling. He called me Tuesday morning. I drove 4 hours that evening and arrived at 11 at night to find my grandfather sitting at his kitchen table with a flashlight because he had not wanted to have lights on under an actively leaking area. I went up to the attic the next morning. The damage was visible. The insulation in the north section was saturated. The plaster ceiling below showed active staining. The decking where the rain had been hitting was discolored and soft in 2 spots. Estimated remediation cost, which I got from a water damage specialist I called that morning, $4,000 to $7,000 depending on what drying out revealed about the subsurface damage. Brecken's phone continued going to voicemail. His website was still up with its 5-star reviews. I called the Tennessee Department of Commerce and Insurance, which licenses contractors, and filed a complaint. I called the Claiborne County Sheriff's Department and asked about filing theft by contractor charges, which Tennessee recognizes as a criminal offense when a contractor takes deposit money and abandons work. The deputy who took the information said they would look into it. I drafted a formal demand letter citing the contract breach, the deposit amount, the documented damages, and the Tennessee Home Improvement Act. I sent it certified mail to the address on Brecken's license. That night my grandfather and I were sitting on his porch when he asked the question I had been expecting. "Sierra, that man left a trailer in my driveway, full of supplies." "I know, Granddad. Those supplies were bought with my deposit money." "Yes. So those supplies are mine in a practical sense." I explained the legal nuance. The supplies were technically owned by Brecken until a court established that the deposit had been wrongfully converted and those materials were the traceable asset. That could take months in civil litigation. He was quiet for a while. The trailer had been sitting in the driveway for 11 days, full of shingles, decking, ridge vent materials, flashing rolls, probably $15,000 to $18,000 of roofing supply. My grandfather finished his coffee. He said, "I have a friend at the county road department who owes me a favor." I said, "Granddad, I need you to tell me before you do anything." He said, "I am going to tell you right now. I am going to borrow a track hoe, and I am going to move that trailer to a location where it will require Mr. Holloway's cooperation to recover." He looked at me with the steady expression of a man who has made a decision. I looked at him for a long moment. Then I said, "If you bury the trailer, you need to document the location precisely so that you can direct recovery efforts when this is resolved." He nodded. "He also needs to receive written notice before you do it." "Notice of what?" "Notice that you are exercising a possessory lien on materials purchased with your deposit funds pending resolution of the contract breach." He looked at me. "Can I do that?" Under Tennessee law, a property owner has a right to retain assets on their property under certain circumstances while pursuing a claim. The legal ground is not perfectly settled for this specific application, but it is defensible and it gives you a documented basis that is better than no basis. She paused. "Send the notice." "Then do what you are going to do." He sent the notice. Certified mail to Brecken's address, email to the address on the contract, and a text message to the number that had been going to voicemail. The notice stated that the materials on the Prout property were being held as security for the deposit funds and incurred damages pending resolution of the breach of contract, and that their removal without resolution would be considered theft of secured assets. He sent the notice on a Wednesday. On Thursday morning, he borrowed the track hoe from his friend Raymond at the county road department, and by 10 in the morning, Brecken Holloway's supply trailer was 4 feet below grade in the northeast corner of my grandfather's 12 acres, covered with the clay soil of Claiborne County, and tamped down level with the surrounding ground. My grandfather smoothed the surface, replaced the sod pieces he had set aside during excavation, and returned the track hoe to Raymond by noon. Then he came inside and told me what he had done. I looked at him for a long time. "Granddad," I said, "that is either brilliant or complicated." He poured 2 cups of coffee. He said, "I have been operating equipment for 41 years. I know where things go when I put them there. I know how to get them back out. And that young man knows where I live. If he wants his trailer, he knows how to reach me." He reached out. Brecken Holloway called my grandfather's number at 4:17 that afternoon. Not voicemail this time. He answered on the first ring. Elias said, "I need my trailer." My grandfather said, "You need your trailer. I need you to call me back. What is your availability?" There was a long pause on the line. Brecken said, "I can come out tomorrow." My grandfather said, "Bring the contract and your insurance documentation." Brecken said, "Where is my trailer?" My grandfather said, "It is on my property. I will show you exactly where when you arrive tomorrow with the contract and insurance documentation." He arrived the next morning at 9. He was alone. He had the contract. He did not have insurance documentation because, as it emerged, his insurance had lapsed in August, 2 weeks before he started my grandfather's job. The provision I had added to the contract requiring current insurance throughout the project had been violated from day one. Part 2, 2455. Brecken Holloway stood in my grandfather's driveway looking at the smooth ground where his trailer had been. My grandfather stood beside him holding a cup of coffee with the unhurried patience of someone who had all the time in the world and knew it. "Where is it?" Brecken said. "It is here," my grandfather said. "On my property." "Where on your property?" "In a secure location pending resolution of our contractual matter." Brecken's expression went through several stages in rapid sequence. Confusion, comprehension, anger. And then, when he looked at my grandfather's face and understood that he was talking to a 79-year-old man who had operated heavy equipment for 41 years and was not going to be moved by volume or urgency, something more calculating. "What do you want?" My grandfather looked at him. "I want my roof finished and my deposit money accounted for and the damage to my house addressed." Brecken said he had experienced material supply issues and had intended to return. My grandfather said he had sent 3 notices to which no response had been received, and that 11 days of exposure had caused $4,000 to $7,000 of water damage to his interior. Brecken said he was not responsible for weather damage during a materials delay. My grandfather handed him a copy of the contract amendment I had drafted, the one Brecken had countersigned. He pointed to the clause requiring notice and documentation for any delay beyond the work commencement date. Brecken read it. Then he looked up. I sat at the kitchen table in my grandfather's house and listened to this exchange from inside because my grandfather had asked me to let him handle the initial conversation. He came inside 20 minutes later. "He wants his trailer and he is going to offer to finish the job," he said. "What is your read on him?" Elias poured coffee. "He is scared." "Not of me, of something else." "What do you mean?" "He kept looking at his phone, not to call anyone, to check something. He was distracted by something that was not this conversation." I came outside. Brecken was standing by his truck. He was 41, broad, and in this morning light looked like someone who had not slept well in several days. I introduced myself and told him I was Elias Prute's granddaughter and his attorney in this matter. He looked at me with the wariness of someone who had just realized the conversation had changed categories. "I want to show you something," I said. I pulled out my phone and showed him the Tennessee Contractor License Database entry for his license number, specifically the notation from 2021, the prior complaint. He looked at it. He knew what it said. "What was the 2021 complaint?" I asked. He was quiet for a moment. "A job in Union County. Materials delay." Similar situation. "How did it resolve?" He said it had been mediated and resolved satisfactorily. I had requested the complaint file from the Department of Commerce and Insurance the previous day. I had it on my phone. The 2021 complaint had been filed by a homeowner named Gerald Marsh in Union County who had paid a 40% deposit for a bathroom renovation that Brecken had started, paused citing materials delays, and not resumed for 6 weeks. The mediated resolution had required Brecken to complete the work and pay a reduced penalty. The complaint file also noted a second complaint from the same period, a different homeowner, similar circumstances, that had been withdrawn after private settlement. I said, "Brecken, I think you have done this before." He did not say anything. "I think you take deposits, start jobs, pull your crew for reasons that have nothing to do with materials, and hope homeowners either wait it out or accept partial completion, rather than go through the process of filing complaints and pursuing claims." He looked at the smooth ground where his trailer was. I said, "I want to tell you what I have done in the past 3 days. I filed a complaint with TDCI. I filed a theft by contractor notice with Claiborne County Sheriff. I sent a demand letter by certified mail and email, and I requested your full complaint history from the licensing board." His jaw tightened. I also made calls to 2 attorneys in Union County yesterday afternoon. One of them is representing Gerald Marsh, who it turns out is interested to know that the contractor whose conduct he complained about in 2021 is doing the same thing in Claiborne County in 2023. He looked at me for a long time. "What do you want from me?" he said. "The same thing my grandfather told you. His roof finished, his deposit accounted for, his damages addressed, and your insurance documentation which you do not have because your policy lapsed in August." He was quiet. "I want to tell you what Gerald Marsh's attorney told me yesterday," I said. "She said she has been waiting for a pattern to emerge. One complaint can be an anomaly. 2 complaints is a pattern. She is interested in whether there are others." "Are there others, Brecken?" He did not answer. I said, "I'm going to find out either way. If you cooperate with me now, that cooperation is something I can document when I speak to the licensing board in the DA's office. If you do not, then I am going to pull every complaint ever filed against your license and contact every one of those homeowners and see what we have." He sat down on the tailgate of his truck. He sat there for a while. Then he said, "There are others." "How many?" He said he was not certain of the exact number. I said I needed him to be more certain. He said, in the past 3 years across 3 counties, he had completed approximately 60% of the jobs he had taken deposits on. He had collected deposits on the other 40% and experienced what he described as cash flow difficulties that had prevented completion. Cash flow difficulties. I looked at him. "Brecken, do you understand what cash flow difficulties in this context means legally?" He said he understood it was not good. "It is not good," I said. "It is theft by contractor under Tennessee Code 39-14-154. It is potentially fraud. And depending on how many homeowners are involved and what the total deposit amounts are, it may be federal wire fraud if you used electronic communications to solicit those deposits." He looked at the ground. I said, "I need a number and I need names, and I need to know if you have any of the deposit money left." He said he had approximately $40,000 in a business account. He had collected, by his estimate, somewhere between $180,000 and $220,000 in deposits from jobs he had not completed in the past 3 years, across approximately 22 to 28 homeowners, in Claiborne, Union, and Campbell counties. 22 to 28 homeowners, $180,000 to $220,000. I went back inside and told my grandfather. He listened. Then he said, "So he has been doing this to other people?" "Yes, older people mostly," I said. That was the profile from the complaint files. Homeowners who were less likely to pursue aggressive legal remedies. He was quiet. "My grandmother's house," he said. He was talking about the house in Union County where Gerald Marsh lived. "Different house, but same thing." "Yes." My grandfather nodded. Then he said, "The trailer stays where it is until this is completely resolved." I agreed. I called Gerald Marsh's attorney, whose name was Denise Odom and who was 52 years old and had been waiting for exactly this conversation since she had been unable to find a pattern in 2021 that she could use to build a broader case. She had Marsh's file open before I finished explaining why I was calling. She had 2 other Brecken Holloway clients she had identified informally since then. She had been waiting. We spent 90 minutes on the phone. Then she called the Campbell County attorney who had handled a 3rd complaint. Then we called the Tennessee Attorney General's Consumer Protection Division together. The division attorney who took the call said she would need documentation before opening a formal investigation. We sent documentation that afternoon. 40 pages between the 3 of us. Complaint files, contracts, deposit records, bank statements were available, photographs of unfinished work, correspondence logs. The investigation was opened within 72 hours. The investigator assigned was a man named Todd Byatt who had been handling contractor fraud for 11 years. He called me on a Friday. "Ms. Pruitt," he said, "this is a more complete initial package than we usually receive." I told him it was a collaborative effort. He said he wanted to interview Brecken Holloway and asked whether I could facilitate a voluntary interview. I said I would ask. Brecken agreed to the voluntary interview, on counsel's advice from an attorney he had retained by that point. because his position had shifted from someone who was trying to manage a situation to someone who understood that the situation was going to be managed without his cooperation if he did not provide it. The voluntary interview produced what the investigation needed to formalize the case. 22 confirmed victims across 3 counties. Total deposits collected and not applied to completed work, $194,000. Brecken's account held $40,000. The remaining $154,000 had been spent on personal expenses, a boat, a truck upgrade, 2 vacations, and what he described as business overhead that he could not document with receipts. The Attorney General filed a civil enforcement action and simultaneously referred the matter to the district attorney for criminal prosecution. Todd Byard filed the referral with a recommendation for theft by contractor charges across all 22 counts and a fraud charge based on the pattern of conduct and the electronic solicitation of deposits. Part 3, 4320. The criminal case moved faster than civil cases typically move because the documentary evidence was complete, and Brecken had been cooperative in the voluntary interview in a way that gave the DA's office a factual foundation that required minimal additional investigation. The district attorney handling the case was a woman named Carol Standish, who had been in office for 12 years and had a specific approach to contractor fraud that she had developed from watching elderly homeowners testify in cases involving contractors who had calculated correctly that older victims were less likely to fight back. She told me in our first meeting that the Prout case was unusual because most contractor fraud victims did not have a consumer protection attorney in the family. Or a grandfather with a track hoe, I said. She almost smiled. The track hoe, she said, is a separate legal matter that we will not be pursuing. I said I appreciated that assessment. She said the documentation of the possessory lien notice, the specific contract language, and the fact that the trailer was on my grandfather's property and had been purchased with his funds gave the situation a legal texture that made criminal prosecution of my grandfather impractical and probably unjust. Brecken's attorney had raised the trailer burial as a potential counter-complaint in the early negotiations. Carol had explained to that attorney that pursuing a complaint about a buried trailer in the context of $194,000 of deposit theft was a strategic choice he was welcome to make. He chose not to make it. The 22 victims were identified through the investigation and contacted individually by Todd Byard. They ranged in age from 52 to 84. 14 of them were over 65. Every one of them had experienced some version of the same sequence: a below-market estimate, a high deposit requirement, work started and abandoned, phone going to voicemail, money gone. 14 of them had not filed formal complaints, some because they did not know the process, some because they had been told by Brecken that the delay was temporary and had kept waiting, some because they were embarrassed, some because they had been told by people around them that these things happened and you just had to accept it. My grandfather sat in the conference room at Carol Standish's office on a Tuesday in November with 11 of the 22 victims and their family members. I had asked Carol if this meeting was possible because I thought it mattered for the victims to see each other. She had agreed. The room was the particular mix of anger and relief that people feel when they discover that something that happened to them individually happened to others systematically, that it was not their fault for signing, that it was not their naivety that created the vulnerability, that there was a person who had made specific choices to exploit specific patterns, and that the specificity of those choices was now documented and was going to be addressed. My grandfather was the oldest person in the room. He sat at the end of the table with his hands flat on the surface and listened to each person describe their experience. He did not say much during the meeting. Afterward, in the parking lot, a woman named Dolores Hutchins, who was 76 and had lost $8,000 on a deck project in Campbell County, took my grandfather's hand and said, "I heard you buried his trailer." My grandfather said that he had moved it to a secure location on his property. She looked at him for a moment. Then she said, "I wish I had thought of something like that. I would have felt better. He said it did not get my roof fixed. She said no, but it got his attention. He nodded. That was the point, he said. Brecken Holloway pleaded guilty in February to 3 counts of theft by contractor, consolidated to represent the pattern across all 22 victims. The Tennessee sentencing guidelines for the total amount involved, and the number of victims produced a sentence of 4 years state prison, 2 years probation, and full restitution of $194,000. The restitution was ordered paid from his $40,000 business account immediately, and the remainder secured against his personal property including his truck, his boat, and his home. The boat and truck were liquidated. The home went a short sale. Total recovery from liquid assets, $112,000. The remaining $82,000 became a judgment debt subject to wage garnishment upon his release. The Tennessee Department of Commerce and Insurance permanently revoked his contractor's license. The revocation was published in the department's public database with a notation of the criminal conviction. His name would appear in that database permanently. Any contractor database search by any future customer would find it. Denise Odom filed a civil class action on behalf of all 22 victims simultaneously with the criminal proceedings. The civil case settled in conjunction with the restitution order. Each victim received a proportional share of the recovered funds based on their deposit amount. My grandfather received $6,300 in restitution from the liquidated assets. He received a second payment, $4,800, from the civil settlement fund. He received a third payment from Brecken's insurance carrier, who had been notified by the criminal case and had a separate professional liability policy that covered a portion of completed work claims. Total received by Elias Prout, $14,900. His original deposit had been $8,400. The overage covered most of the water damage remediation. I arranged for a reputable roofing company, one of the original 3 who had bid the job in the spring, to complete the roof. They assessed the damage, added the remediation to their scope, and completed the work in 6 days in March. The roof cost $31,200 including the additional water damage work. After applying the restitution and settlement funds, my grandfather paid the balance from his own savings. He sat in his kitchen the evening the roofers finished and looked at his ceiling, and told me it was the first time since September that he had felt certain the house was going to be all right. I asked him about the trailer. He said he had excavated it in January, once the civil settlement terms were finalized and Brecken's assets were fully in the custody of the court. He had done it himself with a rented mini excavator because returning the trackhoe to Raymond had seemed appropriate once the legal situation was resolved. The trailer was recovered intact. The materials inside had been in sealed packaging and survived burial without significant damage. The court had ordered them as part of the asset inventory, and they had been liquidated along with Brecken's other property. My grandfather said the clay soil had held well around the trailer, and that excavating it had been straightforward for someone who knew what he was doing, which he did. The HOA connection that I have not yet explained. I should explain it now because it was what gave Brecken his original list of targets in Claiborne County. Clearview Pines HOA, which covered the development adjacent to my grandfather's 12 acres, though my grandfather was not a member of it, had a home services referral program. The program was a board-administered list of preferred vendors that the HOA recommended to its members for home improvement projects. Brecken Holloway had applied for and received placement on the preferred vendor list 18 months before he started my grandfather's job. He had provided the board with references that the board had not verified and a license number that the board had looked up but not reviewed for complaint history. He had provided 5-star reviews from the same accounts that were on his website. The board had added him to the list. 14 of his 22 victims in Claiborne County had found him through the HOA preferred vendor list. My grandfather had not found him through the list. My grandfather had found him through a door knock. But the HOA list had given Brecken a credibility signal that he had used in his sales conversations with homeowners who had found him through the list. "I have the HOA's preferred vendor program," he had apparently told several of them. "That gives you additional protection." It did not give any additional protection. The HOA's preferred vendor list had no vetting standard beyond a submitted license number and self-provided references. The board president who had administered the list was a man named Kenneth Lowell, 58, who had approved Brecken's application without the verification that would have found the 2021 complaint. Kenneth was not criminally liable. He had made an administrative error in a volunteer capacity, but the HOA faced civil exposure for the harm caused to 14 of its members through a program the HOA had marketed as providing additional assurance. Denise Odom added the HOA as a respondent in the civil action. The HOA's insurance carrier settled for $32,000, divided among the 14 victims who had found Brecken through the list. Kenneth Lowell resigned from the board in March. The preferred vendor program was suspended pending a governance review. The new governance structure that the HOA adopted required independent license verification through the state database, reference verification with documented calls to provided references, complaint history review, and annual recertification. The program was relaunched 6 months later with 4 vendors who had passed the full vetting process. None of them had complaint histories. All of them had verifiable references. All of them had current insurance that was confirmed directly with the insurer rather than through a certificate provided by the vendor. My grandfather attended the HOA's community meeting when the new program was announced. He was not a member of the HOA, but Kenneth's successor, a woman named Patricia Oakes, who had taken the board president role with the specific intent of doing it correctly, had invited the affected non-member neighbors as a gesture of acknowledgement. Elias sat in the third row with his coffee in a thermos and listened to Patricia walk through the new vetting requirements. Afterward, she came to him specifically. "Mr. Prout," she said, "I am sorry for what the previous program contributed to your situation." He shook her head. "You did not build the program," he said. "You are fixing it. That is the right order of things." She said she had heard about the trailer. He said that he had exercised a possessory lien on secured assets pending resolution of a contract breach. She looked at him for a moment. She said, "Is that what that was?" He said, "That is what my granddaughter told me it was." She almost laughed. We drove home through Claiborne County on an April evening with the hills green and the light long and my grandfather quiet in the passenger seat with his thermos. He said, "Your grandmother would have liked to see that roof." "I know," I said. "She always said the north slope needed replacing." "She was right," I said. "She usually was." He was quiet for a while. Then he said, "Sierra, that young man figured that old people would not fight back." "I know, he was wrong about that. I know, Granddad." He looked out the window at the hills going past. "I have been moving earth for other people for 41 years, he said. "A man comes along and thinks because I am 79 he can take what is mine and walk away." I looked at the road. "How did that work out for him?" I said. My grandfather poured the last of his coffee from the thermos. He said, "About as well as most things work out for people who do not do their research before they start digging." He drank his coffee. I drove. The hills were green in the evening light, and the road ran through them the way roads in eastern Tennessee run through hills, which is to say with the specific indifference of geography to the human concerns being worked out along it. My grandfather's roof was solid. His ceiling was dry. His house was the house he had built in the summer of 1967, and it was going to stay that way. If you are dealing with a contractor who took your deposit and has gone quiet, document everything immediately. Every call attempt, every text, every email. Photograph the work site condition. Read your contract for the clauses that protect you and the ones that do not. File a complaint with your state licensing board. Contact your state attorney general's Consumer Protection Division. And if the contractor left supplies on your property purchased with your deposit funds, call a lawyer before you do anything else. Because what you do next matters for your legal position. And because what my grandfather did while deeply satisfying and ultimately defensible, required a specific set of facts, a specific contract provision, a specific notice, and a granddaughter who could explain what a possessory lien was before the track hoe started. Hit the like button if you believe that 79 years old is not too old to know exactly what you own and exactly what to do when someone tries to take it. Subscribe for more stories about people who knew their rights and refused to be the kind of victim someone thought they were picking. And if you know someone who has been taken by a contractor, send them this. Because sometimes the most powerful thing you can do is read every document you signed and call someone who knows what those documents mean. Framed thumbnail text. Contractor abandoned MY grandpa's roof. Subtext: excavator buried their supplies.